أعوذ بالله السميع العليم من الشيطان اللعين الرجيم. بسم الله الرحمن الرحيم. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. Respected Sheikh Nuru, my elders, brothers, sisters, Assalamu alaikum jami'an wa rahmatullahi wa barakatuh. First of all, a big thank you to the organizers, to this community for hosting myself and Sheikh Nuru, and to Sheikh Nuru again for hosting this presentation with myself. We've been blessed to deliver this seminar at least 3 or 4 times in various communities, and the feedback that we've received is that people have benefited from it. They've taken a lot away from it. So I hope inshallah that is the case for all of you as well. I was just looking at this quote that's on the wall there: walk in strong, walk out stronger. And I want to change that, because you've walked in today maybe a little bit confused about the whole situation about making wills. You're going to walk out more confused today, because my presentation is going to give you an overview of some of the rules that exist in the laws in this land. But they are very complicated and they're very complex, and we're going to navigate them as best as we can. My title is Wills, Succession and Inheritance Tax, an overview of the law of England and Wales. So I just want to start off with a disclaimer that the laws that I'm going to talk to you about today are the laws that apply in this country, the country that we all live in, England and Wales. If you have connections to another country, as many of us may do, to our home countries, whether that may be India, Pakistan, East Africa, if you have assets in those jurisdictions or anywhere else in the world, what I'm about to tell you doesn't apply to those assets. We can work with legal advisors in those countries to help you coordinate everything so that it is in accordance with the laws of that land, the laws of this land, and with the Sharia. But what I'm about to talk to you today only applies to this country. When it comes to the Sharia points, there are always people like Sheikh Nuru and his colleagues who I seek guidance from if there are any points from the Islamic aspects that I feel confused on, and there is still a lot that I'm confused on. And it wouldn't surprise me if there are many of you that will still be confused on some of the Islamic points. I think one of the things to mention is that Sheikh Nuru has also given a very brief overview of the fiqh surrounding the laws of inheritance and the wasiyah. And even though it may not seem like it, what I'm about to give you is a very brief overview of the laws of this land. It is inherently much more complicated than what I'm about to discuss. What I'm about to discuss is complicated, but the reality is even more complicated than that. So I'm going to try and break it down and keep it as simple as possible. Today's presentation contains generic content. Okay, so it is not directed at anyone's particular specific circumstances. This is generic content that is out there in the public domain, which is very confusing, but which I'm trying to pull together in a way that allows us to understand the laws of this land, but also how it interacts with the Sharia. And what you will see as we go through is that the laws of this land, particularly when it comes to inheritance tax, are at direct odds with the Sharia. It is almost impossible to write a will that is strictly in accordance with the Sharia as Sheikh Nuru described and still not be subject to a large tax bill. It is impossible. So my role is to help people navigate that and to try and fulfill the Sharia objectives as best as we can. Sometimes it's not always possible, and then we leave it in the hands of Allah subhanahu wa ta'ala, because we have done our best to the extent that we can, and we have to rely upon then on Allah's mercy. So today's presentation contains very generic content. For your personal circumstances, you are always advised to seek your own legal advice. This is just generic content today. And my aim, as I said, is to educate and to raise awareness into this very important but very complicated area. I'm not going to discuss any personal circumstances, because every family is unique. Everybody's set of finances is unique. We can't sit here and discuss everybody's personal circumstances, but hopefully this will allow you to input some of what we have said today into your life and navigate as to where you might need some advice and some help into getting your affairs sorted out. What I'm not going to give you today is a template will. Often people come to these seminars and they want to take home a template will that they can fill in and sign. I'm not going to do that, because in my experience that's very dangerous to do. The reason for that is that sometimes people fill in these wills, but they don't have any indication or understanding as to the legal impact of what they're writing. And it is often the case that where people have written homemade wills because they haven't thought to sought the advice of someone qualified, when that person passes away, it does leave behind a very big mess, and often it costs a huge deal to sort out the mess that they have left behind. Sheikh Nuru has touched upon things like family disputes, family circumstances that can blow up when somebody passes away. Yes, that happens. But when it comes to sorting those things out, and you have to have recourse to the legal courts, which is often the case in these situations, not only is your dispute out there and your odds with your family members, it also becomes very heavy upon your pocket. It becomes incredibly, incredibly expensive. So spending a bit of time and investment in lifetime to get these things sorted out, as our brother will tell you, towards the end of the seminar, Brother Muhammad Hashir, who's going to talk about protecting your assets in lifetime, a hugely important topic. This is about protecting the wealth that you have built up over your lifetime for the benefit of your family. So in the same way that we invest in everything in our life, this is something that we need to put in a small investment into. So to start off with the obvious question, under English law, what is a will? So a will is a declaration of wishes that is intended to take effect only upon the death of the individual. The individual who passes away, as Sheikh Nuru mentioned, is called the testator. Just actually before I go any further, what I will say is, by all means, if anybody wants to take notes, please do so. If you want to take pictures of the screen, please do so. But I will make these slides available after the seminar. So there is a lot of content on the slide, so please don't feel you have to copy everything down. I'd rather you listened and focused on that, and inshallah, by Monday I will send an updated slide that can be circulated. So please don't stress yourself if you don't get everything down. I'd rather you listened and absorbed, and then you can look at the slides and revisit things at your leisure. So a will is a declaration of wishes that is intended to take effect only upon the death of the testator. At that point, at the point of death, it becomes a legally binding document. The testator, the individual, can change their will at any point up until their death. Sometimes people think that I've written a will, that's it, I don't need to do one again. A will that you write today, may Allah give you a long life, may not reflect your circumstances 20 years down the line. So a will continuously needs to be reviewed and updated. So the will can be revoked at any point up until the point of death. However, you can only change that will if you have the requisite mental capacity to do so. Now, generally, sometimes as people get older, they can be inflicted with illnesses and diseases that impact their ability to make these decisions coherently. Mental capacity can become an issue certainly as we get older through the natural aging process. For somebody who is young, an accident, anything like that can affect their ability to function. So the will can be changed at any point, so long as the person changing it has the requisite mental capacity. That basically means they understand what they're doing, they understand the effect and the content of the will, and the implications that it will have upon the people who are benefiting. Okay, so mental capacity is really important. And when somebody, particularly an elderly individual, comes to me, one of the things that they may not even realize that I'm doing, I'll have a conversation with them, I'll try and get as much information as I can about their family circumstances. It's not me being nosy, it's me just trying to ascertain how is this individual operating, what is their cognitive function like. So we're continuously assessing capacity, particularly where people are elderly, to understand, can this person actually understand what it is they're trying to do here? It's really important. Because a will can be challenged by the beneficiaries if the person making it is found not to have the right mental capacity at the time that they make it. So it's really important that there is a record on my file that that person is fully aware of what they're doing. And in order for a will to be valid, and we'll look at this in a few moments' time, there are certain legal formalities that need to be observed in order for that will to be valid. Sheikh Nuru will correct me if I'm wrong, but under Islamic law, even according, I believe, to the rulings of Sayyid Sistani, a wasiyah can be an oral direction. It can be verbal. You don't necessarily have to write it down, although as we know the Quran recommends that whenever we have transactions or we have wishes we write them down, but strictly under Islamic law the wasiyah can be oral, so it can be binding upon the wasi, the executor, to implement that will as long as it has been orally communicated to them. Under English law that principle does not apply. A will has to be written, and we'll look at that in a few moments' time. So why would we write a will? Sheikh Nuru has given us the Islamic philosophy and perspective on writing a will. He's given us some of the disadvantages, the punishments that we may face, the adab that we may face of Allah subhanahu wa ta'ala if we don't write a will from an Islamic perspective. If we put that to one side, from an English law perspective, why should I write a will? The first, and as Sheikh alluded to, is that it gives you control over the distribution of your estate at the time of death. Here in this country, we have a system called testamentary freedom. Testamentary freedom basically means that with very few constraints, I can leave my estate to whoever I like. I can leave it to my mother, I can leave it to my father, I can leave it to my spouse, I can leave it to the charity, my mosque charity, I can leave it to anybody whom I want. I have very few restrictions on who I can leave my estate to. Conversely, Sharia is a system of what we call forced heirship. There are certain parts of the estate that you have no control over, which is the 2/3 that Sheikh Noor mentioned. When you go to countries, for example, in the Middle East, you go to Saudi Arabia, you go to Iran, you go to the UAE. In those countries, unless you are a non-Muslim, if you're a Muslim living in those countries, there's no concept of writing a will, because automatically your estate passes according to Sharia. You have no control. So a lot of people in that part of the world, they don't place importance upon this because it's automatic according to the laws of their land that their assets will be distributed automatically in accordance with Sharia. We don't have that principle here in the UK. And I will explain what happens in a few moments' time if you don't write a will, how your estate is distributed. So the point that I'm trying to make here, the distinction that I'm trying to make here is that under English law, you have control over 100% of your estate. Under Islamic law, you only have control over 33% of your estate. Okay, so that's the first difference. We're going to tease out the differences as we go along, so you will see how these two systems are in direct conflict with one another. The second thing that the will allows you to do is to choose your executors. Your executors are the people that are appointed and named in your will that will carry out the wishes that you write in the will. In Islamic terminology, we call this the wasi, right? One of the titles of Imam Ali alayhi salam is Wasiya Rasulullah, the one who was the executor of the will of Rasulullah. Allahumma salli ala Muhammad wa ala. It's one of the greatest titles that we have of Amir al-Mu'mineen, the one who was given this responsibility, this authority to administer the estate of Rasulullah when he passed away. So it is a very high position, a position of extreme responsibility. We will see in a moment's time who we can appoint as executors under English law, and Sheikh Noor can explain to us who can be an executor under Islamic law, because sometimes they're different. But the position of executor is a highly responsible position. So if you are asked to be one, it is an amana upon you to make sure that you fulfill the wishes of that testator, of that deceased, in the way that they have requested you to do so. The third one, which is extremely important, is to minimize inheritance tax when you pass away. Just a quick show of hands. How many of you are broadly aware of what inheritance tax is and how it operates in this country? Okay, so a few hands going up, but a lot of people that potentially have not heard about it. And this is where the problem is. Okay, the fourth reason for writing the will is what we call administrative convenience. For the simple reason that when you have a will, the practicalities of dealing with assets when somebody passes away becomes much easier. Closing bank accounts, selling property, all of these, the realization of assets becomes much simpler when you have a will as opposed to the situation when you don't have a will. It can be done, it's just more long-winded and more costly to implement. So having a will simplifies that administrative process as well. So an overview of what we're going to talk about today. This is the main presentation, okay? There's 41 slides, okay? Sheikh Noor and I have done an advanced version of this seminar at Stanmore in last July, I believe, where we focused on different aspects of inheritance tax. I don't think we're going to have time today. If we can get through the basic 41, that's good enough. But maybe inshallah we can have a follow-up at some point to go through more specific scenarios. But this is what I intend to cover today. The first thing is, what does your estate include? Number 2, key things that you should think about including in a will. Number 3, what do I need to do in order to ensure that my will is valid? Number 4, some miscellaneous points that we just need to cover. Number 5, the consequences of dying without a will in the UK. Number 6, inheritance tax. Number 6 is where I'm going to spend the most of my time today. 1 to 5 are important, but I'm going to go through them quite quickly. They're very important, so please be aware of them, but number 6 is where I'm going to spend a lot of my time. Number 7, the interaction between English law and Sharia law. And we'll look at, for example, the situations that Sheikh Nuru mentioned, that you might wish to give your wife the additional 1/3 in addition to the 1/4 that she gets. We'll look at the implications of something like that and how that still might not necessarily work well with English law. Okay? Everybody with me so far? Yeah? Okay. At any point, if I'm going too fast or if you're confused, please do stop me, because I'd rather you understood where you were and rather than me going through and you getting confused. Okay, so question number 1. What does your estate include? So under English law and Islamic law, your estate includes everything that is in your possession at the time of your death. And that can include absolutely anything. It can include cash. It will include your personal possessions. So cash, not just the cash you have lying around loose in your house. I mean cash in your bank accounts and your ISAs, okay? Your personal possessions, your clothes, your jewelry, your personal effects. Any property that you may own, whether it's your main home, whether it's any investment property that you may have. Any investments that you may have, stocks and shares, portfolios, all of these things, when I get, crypto is a very hot topic these days. We're still navigating how to deal with it from a legal perspective. I know the scholars are having their own discussions surrounding how crypto is to be viewed at from an Islamic perspective, but these are all assets. Even though they're not tangible, so to speak, they are your assets and they are in your possession. From an English law perspective, your assets also include any assets that you hold or own outside of this country. So if you are what we call domiciled in this country, which means the UK is your permanent home. You may have come from another country originally, but you have settled now in the UK and you have made the UK your permanent home. Where that is the case, even those foreign assets form part of your estate. And it is your obligation to deal with all of those assets properly, in accordance with the law of the jurisdictions where those assets are situated, the jurisdiction in which you live, and the religious law to which we are all subject to. So 3 legal systems, so to speak, that we have to have consideration of. So you can see it's a very complicated thing. What does your estate not include? Okay, now Islamic law differs on this slightly. But from a legal perspective, anything that you hold jointly with somebody else. So people may have joint bank accounts with their spouses. People may have joint property with their spouses. Those assets will pass automatically, generally, to the joint owner if they are held as what we call as a joint tenancy. Okay, and that tends to be how most married couples hold property. That in itself is a problem because there are restrictions upon women holding land in Islamic law, but we're not going to get into that because that makes things even more complicated. Okay? We'll assume that women can hold land because that is the reality and the normality of the situation today. Okay? So we can address that minute point later on, but for now let's just assume that we can all hold land as women. So under a joint tenancy, anything that you hold with your joint owner passes automatically to the other joint owner. So if I had a bank account held with my spouse, if I died, that account automatically goes to him. If I have a bank account held with my daughter, if I die, that automatically goes to her. Okay? So property can be held as a joint tenancy or what we call as a tenancy in common. And this tends to be, tenancy in common is more common when people are on second marriages, for example, or if people have put in different deposit amounts into the property. So they want to actually reflect a proportionate share of what they have put in. That's where you hold a property as a tenancy in common. I'm not going to dwell too much in it. But the difference is that where you have an asset held as a joint tenancy, which is what most of you will have, that is not part of your estate. So that means it can't be covered by the will because it automatically goes to the other person. But it is part of your estate for tax. So we'll come back to that. So it is not part of your estate because it automatically passes to the joint owner. Anything that you hold as a tenancy in common, which is where you have a distinct share of that joint asset. So you could, for example, say, I'm holding a property with my spouse, but because he put in more money, he holds 75% and I hold 25%. That's what we call a tenancy in common. And that 25% is part of my estate, and I can deal with that in my will. Are you with me so far on the distinction? Yeah? Okay. Yes.
So just to confirm, you said that if it's a joint tenancy, it would still be classed as your estate for inheritance.
For tax, yes.
But for the rest of it...
But yes, for basically what that means is the value of that asset is included as part of my estate when I'm calculating how much tax is due. But in terms of where it passes, it goes automatically to the other person. Yeah? Okay, so other assets that are not part of your estate, and as our brother will hopefully talk to us about later on, insurance policies, life policies. Sometimes when we buy property, we are obligated to take out life insurance policies to make sure that our spouse has enough to pay off the mortgage in the event of one of us dying, for example. If I was to write that policy into trust, and I'm sure our brother will cover why this is important, but if I take out a life policy and I write it into trust, and I say that when I pass away, this policy goes into a trust. The beneficiaries of that trust are my spouse and my children. Because I don't have any direct benefit from that trust, that policy is now no longer part of my estate. Its value is no longer part of my estate. I can't say in my will, give my policy to whoever, because I've already passed it into a trust in my lifetime. Are you with me? I don't have control or ownership rights anymore over that asset because I've given it away into that trust. And again, it's very common planning for inheritance tax. When people have got insurance policies, we tell them, put them into trust. Because when you put them into trust, it goes to the trust, it doesn't come to your estate, and therefore your policy is not taxed at 40%. So it's really important. So that policy is no longer part of your estate. And there's a change that I'm about to talk about, but your pension. Many of you will have accrued pensions, right? From years of working, wherever you may have been working. Civil service pensions, private pensions. Some of you may have something called death in service benefits with your employer, yeah? Death in service benefit, it's like a life insurance policy. That if, let's say, you're earning £50,000 a year, your employer might have a policy where they will say that if you die, for any reason, whilst you are in our employment, we'll pay out to your family 2 times, 3 times your salary. Some of you will have that within your employment packages, right? I can see some nods. When you are told by your employer that you have that policy, they will give you a form to say, list the names of the people that you want that payout to go to in the event of you passing. That policy, again, you have no control over because you've already said in my lifetime, when I die, this money is going somewhere else. So strictly, that money is not part of your estate anymore because you've got no control over it. One change that was introduced in the budget this year, which is going to have a huge impact on a lot of people and is already having a lot of my clients panicked, is that up until now, if you had a pension or you had a death in service benefit policy with your employer and you filled in that nomination form and you said that when I die, it goes to X, Y, and Z, X, Y, and Z would receive that policy or that pension completely free of tax. From April 2027, the government has said you can still say it's going to X, Y, and Z, but that pension policy that you haven't drawn down upon, that death in service benefit that pays out when you die, it is now no longer free of inheritance tax. It's subject to 40% inheritance tax. And I'll just give you an illustrative example. I'm acting for a young gentleman within our community, a young husband and wife from our community. He's, mashallah, done very well for himself in the corporate world. And he has a death in service benefit with his employer of 20 times his salary. Right, so he's very high up in the corporate world. So you can imagine that pays out a couple of million when he passes away. If he dies before 2027 and he nominates his children to get that policy, they will get that 2-3 million, whatever it is, completely free of tax. Post April 2027, that 2 million payout will be subject to 40% tax. So I did the calculations for him that if he dies before 2027, his tax bill is about 50,000, 60,000. If he dies after 2027, his tax bill is just shy of 1.1 million. That's how big the impact is going to be for a lot of families, and it's going to affect everyone in this room that has a pension. Because you might have a house, you might have assets that are under your threshold for tax, but when you add your pension, it takes you above the threshold. Anything above that threshold is going to be taxed at 40%. So that's a huge change that's come in. And the irony was that when the Chancellor mentioned this change, she didn't talk about the impact, she didn't talk about the effect, she just mentioned it as a one-liner and moved on. But it has caused shockwaves throughout my industry because there are now people panicking about how do we now restructure our pensions? What do we now do to make sure that we have our pensions as tax efficient as possible? Okay, that's just a small example. So what sort of things should we be thinking about including in our will? And these are some of the common things that most of the clients that I work for would include. Burial wishes. Now, funeral wishes in an English will are not legally binding. Okay? They're not legally binding. It's important, but less so, I would say, in our communities because we have a standard system of ghusl, kafan, dafan for every single person, right? But when I'm acting for non-Muslim clients, they have very different wishes about what they may want. Some may want a non-religious service or a humanist service, or somebody may want a cremation, or somebody may want a burial. And because their process is not as fast as ours, there is time to look at the will and see the instructions. In our communities, in our sort of faith perspective, it's much more difficult. Somebody dies tomorrow, they're buried the very same day. Nobody has time to look at the will and see if they have specific wishes. So if you are an individual that has got some very specific wishes surrounding your burial, the recommendation is obviously to speak to your family members so that they are aware. So again, I will have clients that come to me and say that, if I die in ziyarah, for example, I want my family to leave me and, leave me there, get me buried in Wadi al-Salam or in Karbala, whatever it may be. If I die whilst I'm on Hajj, because I'll tell you, Hajj season is one of my busiest times for Muslim clients. People will come 2 days before they're going on Hajj, I need a will. It doesn't work that way. You need to be, a bit more prepared before you go. It's not just a 2-day thing, right? There's a lot of discussions that happen. So burial wishes, yes, they're important, but not so much for us unless you have something very specific like that, okay? Appointment of executors. You remember I just mentioned that the executors are in a position of huge responsibility. So who do we appoint? So under English law, there are generally few restrictions on who you can appoint. So under English law, generally, you can appoint up to 4 people by law. Some people don't go for the whole 4. Some people will go for 2, 3. It depends on your family dynamic, right? Some people will just appoint their spouse. Others will say, if my spouse is not there, then I appoint my kids because I want my spouse to have full control of everything. I don't want my kids interfering in any decisions that my spouse may make, right? So you can have up to 4. They have to be adult, so they have to be over the age of 18. If your estate is particularly complex, if you are blessed with an amount of wealth, or if you have, let's say, I don't want to say complicating factors, but if you're, let's say you've got a business, you've got your own family business, you're an entrepreneur, you've got assets all over the place, the estate is a bit more complex, or you've got difficult family circumstances. Let's be real, just because we're Muslims doesn't mean we don't have problems with our families. Shaykh will tell you, we probably have more problems with our families than anyone. And as Shaykh said, the disputes that he sees, the disputes that we see, I have seen them arise in the families of alims as well. So nobody is immune from these disputes. Right? So professional executors are a solution if you have got complex assets or complex circumstances or difficult family circumstances. You might wish to appoint an independent professional. That can be your solicitor, that can be your accountant, that can be Shaykh if he decides to take on the role. I wouldn't advise him to, but if you wanted to ask him, it could be your financial advisor, whoever it may be, a professional that is objective and to some degree removed and distant from the family, that can act objectively between all of the beneficiaries. So some people will go for a professional as well. For those of you that have minor children under the age of 18, appointing guardians, legal guardians in your will is incredibly important. Your legal guardian their role will only take effect if you and your spouse both die. But again, being realistic, if you're traveling together and something happens and you and your spouse are both killed and your minor children survive, there needs to be, and this has happened, there have been cases like this that have happened within our communities that we've seen. Allah forbid. Those children need legal guardians. Somebody who will not only look after them and care for them and nurture them emotionally, but somebody who will safeguard the financial assets that you leave behind for them until they get to the age of at least 18. Remember that when we're talking about adulthood in Islamic law, we're talking about the age of bulugh. So 13, 14, 15 for a male, 9, 10 or so for a girl. When we're talking about adults in English law, it's always 18. So guardians is incredibly, incredibly important. Who will safeguard and look after your children and look after the wealth that you leave behind for them in the event of you and your spouse both dying? The guardians sometimes can be the same people that you appoint as your executors. So the same people that have control over your wealth are the same people that have access to that wealth for your children. They don't have to be the same people, but usually they are. And if you choose different people to be your guardians and different people to be your executors, one of the most practical considerations is you've got to make sure they get on with each other. You've got to make sure they work together. You know, I had a case once where the husband wanted to appoint his family, who didn't get on with his wife's family. He wanted to appoint them as executors because they knew everything about the family finances. But he knew that the kids were close to the wife's sisters and brothers, so he wanted to appoint them as guardians. That didn't work. The two families didn't get on. So all of these practicalities have got to be considered. If, say, for example, you have anything specific that you want to leave to somebody, you might want to make a gift of, let's say, £1,000 to your niece or your nephew for the help that they have given you in your life, whatever it may be. You have a particular asset that you want to give to someone. That can be something you include in your will. And as Sheikh mentioned, something like your outstanding salah, your outstanding saum, your khums, your zakat. Khums, I believe, is wajib the second that you know that it is due. But there will be many that come to me and say that I have years worth of outstanding khums. Yeah. And I will say to them, pay it now, but I don't have the money. Well, then it will have to go into the will and come out of your estate. But making provision, and Sheikh is absolutely right. I have this discussion with people all the time, that I have 5 years worth of outstanding salah. You know, and it's very funny because it's always the men that stand there smugly and say, I don't have any salah. And the women are like, well, I gave birth and I have outstanding fasts and I have this. But unfortunately, this is something that has to be made up. And just coming back to what Shaykh said as well, I will have people that come and say to me, I have 5 years worth of salah. I once had a husband and wife that came to me, and the husband said to me, 5 years worth of outstanding salah, maybe 5 years worth of outstanding fast, just to be on the safe side. The wife said to me, a very interesting point, she said, I prayed my whole life, I fasted my whole life, I've kept all of my qazas, I have nothing, but I still want to do 70 years worth of qaza, because if nothing has been accepted, then this will at least be accepted. And the husband said to her, he looked at her and he said, how dare you doubt the mercy of Allah subhanahu wa ta'ala. So you will have people that will want to overcompensate as well. But if you do have these outstanding obligations, if you do have any qaza salah, any qaza fasts, obviously the obligation is to make them up whilst we're still alive and able to. But if you can't, then at least make sure it is documented in your will so your executors know to leave aside a portion of money to have that implemented. And if you go on websites like the World Federation, and I'm just throwing these charities out, I have no affiliation with any of them, but I'm just throwing them out as examples. For example, the World Federation has a list of rates. You know, how much does it cost for 1 year's worth of qaza salah? And it's surprisingly cheap, £150 for 1 year's worth of outstanding salah to be performed on your behalf after you die. Right? So obviously the obligation is to make it up whilst you are able to. But if you cannot, to make sure that it's documented. And things like radd mazalim. Now one important difference here, I'll come to you in a second. One important difference here. Under Islamic law, these payments come out of your 1/3. Under English law, we class these as legacies. So they're paid first, and then your debts, and then the 1/3 comes into operation. So that's the difference here. Sorry, you had a question.
If you've got wajib salahs and fast for your father side, if you pay for it yourself and it's not come out of the will, is that okay?
My view is that would be absolutely fine, because you're doing in some ways a sadaqah on behalf of a deceased parent. So I would say there's no problem in that, and look, Sheikh agrees. So this is it. People will often make provision in their will for, I want to leave, £500 for X many years worth of outstanding salah. Often what will happen, and this is because we are so aligned to our faith. Often what will happen is that the family will come forward and say, let's just pay it now, we'll reimburse ourselves and deal with that payment later, because we don't want this individual to suffer any adhab in their qabr. So a lot of the times the family will come forward, and once they know how much to pay, will pay it immediately from their own pockets. Many won't even ask for compensation back. But the point here is it's the obligation of the deceased to make sure that is at least communicated to the heirs. It should come out of the estate, but if the heirs choose to step up and pay it from their own pocket, then that's not a problem. That's a khair that you're doing on behalf of that deceased marhum. Right? But even things like, for example, radd mazalim, and Shaykh can explain more about this. Payments like this when you've wronged somebody in your life. These payments can also be implemented within the will. So these are all things that we have to have regard to within our will. Then we list how we want our estate to be distributed. And our estate is then distributed once any debts that we leave behind have been paid off, once any expenses have been paid off, because administering an estate is an expensive task. Once that money has been paid off, once any tax, if that is due, has been paid off, once any funeral expenses have been paid off, then what is left behind, you can set out how you want it to be distributed. Now, many of us will also be members of communities that have like a funeral plan or a burial plan. So many of us will not necessarily be incurring those burial costs when we pass away. But if, say, for example, I certainly know in my own community that if I was to, let's say, for example, I'm part of the Haydari South London Jamaat burial plan. If I was to travel up to Birmingham and die in Birmingham, and I, had a wish that my body was to be taken back down to Haydari, then although my funeral is covered, there's an additional cost for bringing my body back down. That would then have to come out of my estate, right? But generally, for those of us that are part of these burial plans with our Jamaat, the funeral costs tend to be covered, unless you go for something extra, shall we say. Okay, so is everybody with me so far? Yeah? Okay, so in order for a will to be valid, the individual must be over the age of 18, okay? Under Islamic law, again, we're teasing out the differences. You make a will when you have something to leave at the age of bulugh. Under English law, I can't make a will until I reach the age of 18, even if I have assets beforehand, okay? I have to have the sufficient mental capacity. So as I said, I have to understand the reason for making a will, I have to understand the extent of my assets, and I have to understand the impact of what I leave behind. I have to understand the impact that it will have upon the people that I leave behind. I have to understand that if I leave it to you and not to you, am I putting the other person in more financial difficulty? I have to have cognizance of all of these things. I have to understand this. And these are the conversations that I have to have with clients. The will should be made without any pressure from anyone else. And this is hugely important, because often I will see people coming in to do wills. I'll have mum and dad there, and the son or the daughter will always want to be part of that meeting. They'll want to talk, they'll want to explain everything. Now, if the parents say, I want the son or the daughter to be there because they're involved in the finances, that's fine. But the decisions have to come from the actual people making the will. The will should not be made under pressure from anyone else. And there have been times where even in our communities, I've had to ask people to say, please leave the room, let me speak to your mum and dad alone, because they're clearly not getting a word in. So we have to be quite firm and make sure that whatever is coming out and whatever is put down on that piece of paper is actually the intentions and the wishes of the person that is making that will. A later will revokes an earlier will. So let's say, for example, I sign a will today on the 14th of December 2024. And the following week I change my mind, I make an amendment, and I sign a will on the 25th of December. That later will automatically cancels out the earlier will, okay? Marriage automatically revokes a will. This is something that people are not aware of, okay? If I make a will today as an unmarried individual on the 14th of December 2024, I make a will today, I'm not married. Let's say I get married in 6 months' time, and in the excitement of everything that's happening in my life and this new bed of roses that I'm about to enter into, I forget to update my will. At the point of my marriage, my legal marriage, my will is invalidated. I am then treated, if I die without updating the will, I'm then treated as dying without a will. And that can have severe consequences. We'll see in a second what it means to die without a will. Interestingly, divorce does not revoke a will. So if somebody is getting divorced, that doesn't cancel out a previous will that they have made. It just means that their spouse is treated as having been crossed out. So if your will says, I give everything to my spouse, but if she's dead, then it goes to the children, then the will is just treated as being read that the spouse has already died and everything goes to the children. But normally divorcing couples will also update their wills, because nobody wants a legal document with the name of a person they're no longer affiliated to on it. Just coming back on the marriage point, if you are somebody that is getting married and you're engaged and you can identify the person that you're getting married to, you can make a will as what is known as a will in contemplation of marriage. So if I know I'm getting married in June next year to Mr. X, I'm not, by the way, I'm just giving an example. But if I'm getting married next year to Mr. X, I can say, I am making a will on the 14th of December 2024 in contemplation of my marriage to Mr. X, and when I get married to Mr. X, my will still be valid. So the will, if you're engaged, you have to make the will in contemplation of marriage, because if you don't, then it's treated as being revoked by your marriage. Everybody with me? Yeah? And then I've just put a question mark, the separate will for foreign assets. As I mentioned right at the beginning, that there are different rules in different countries, both from a tax perspective, both on how assets are to be distributed. So where you have got assets in a different country, especially property that is located in a different country, and that is very common within our communities. People will have, their ancestral homes, the homes that they leave behind in their home countries, that are governed by different laws. So you might very well need to have a separate will dealing with your assets in a different country. A will has to be in writing. So again, Islam says orally, but English law, it has to be in writing, and it must be signed by the testator. I've put a question mark, the signature in English. And the reason I've put this is that a couple of years ago, I had a case where I had an elderly lady, and I didn't prepare her will, but the family came to me after she had passed away. And they wanted me to deal with her probate and her administration. And when I looked at the will, her signature was written in Gujarati, in the Khoja sort of ancestral language. Her signature was in Gujarati. The will itself was in English, but the signature was in Gujarati. And that's not uncommon. I've had people sign their wills in Arabic. I've had people sign their wills in Urdu. I've had people sign their wills in whatever language they're comfortable with. And up until this point, I never gave it a second thought. When this will was admitted to the probate registry for probate, it was rejected. Because they came back and said that because this lady has signed her will in Gujarati, we can't be certain that she understands the contents of the will, because she signed it in a language that is different to the will. If it had been a will written in Gujarati that we could have got translated, that may have been accepted. But because it was a will written in English and signed in Gujarati, they came back and said, we can't be sure that she understands what she's written, so therefore we don't know if pressure has been placed upon her to make a will in this way.
Are you talking about where she signs her name?
Her name, yeah.
Her actual signature.
Correct. So I think when you kind of go back to that sort of generation, that there's no concept of signatures, right? Things were done with fingerprints and that. So we're talking about somebody who was in her 80s. So having a signature in the way that you and I would now sort of, develop, it was different. So she was told that this is a will, this is what it does, she'd understood it. Now if somebody signs in a different language, so since then I've learned, if somebody signs in a different language, I have to change the wording in the will to say that so-and-so is signing in a different language, and I, the person preparing the will, have read it to them before they sign it, so I can be sure and testify that they understand what they're saying. But that wasn't something that had crossed my mind up until that point. So again, very important. And in this case, it didn't matter so much because this lady had 7 children. Her will left everything equally to her 7 children. Even though the will wasn't accepted and she was treated as dying without a will, the legal position was that everything went between those 7 children anyway. So the effect wasn't lost. But if you've done something different to what the default legal position is, then it can be quite problematic, right? So again, very important. One really important thing, must be signed in the presence of 2 adult witnesses who must also sign. Those witnesses and their spouses and their children cannot benefit from the will. So if I'm writing a will today and I'm giving something to my brother, neither my brother nor his spouse nor his children can be the witnesses to that will, otherwise he loses whatever I have given to him in that will. The witnesses have to be completely independent people. So use neighbors, use friends, use sheikh, use me, whoever it may be. The witnesses are not entitled to see the contents of the will. The witnesses do not have to be told what you're doing in your will. They just need to be told this is a will that we're witnessing, and if they agree to that. And the important thing is the 2 witnesses and the person signing the will, they must all be in the same room together, and all 3 parties must see each other sign that document. Often what will happen is somebody will sign a will at home, then take it to mosque and be like, Zahra, can you witness my signature? But I didn't see you sign it. So therefore I can't witness it. The witnesses and the person signing must all be in the same room. Again, I will have people saying, I'm leaving for Hajj tomorrow, I've written my wishes on the back of this piece of paper, I've signed it, and therefore they think it's valid. But it hasn't been witnessed by 2 people. So even if you die in Hajj tomorrow, that piece of paper is meaningless. I have literally had people do that seconds before they step on the plane. Right? Witnesses is important. The witnesses and the testator, the person making the will, all 3 of them must be in the same room within vision of each other, and all 3 of them must see each other sign. And the reason that is important, because if there is any dispute over the terms of the will, which happens regularly, Those witnesses will be called before the court to sign a statement and swear under oath and say we were there in that room. And if you as a Muslim cannot swear under oath that you were there and you saw that happen, then that's between you and Allah. So I, hand on heart, have to say that when I signed as a witness, I saw all 3 people in this room signing this together. So the role of the witnesses is also, again, very important. They don't have to be specific people apart from being adults and not connected to you, but their role, again, is also very important. Throughout COVID, we had this concept of being able to witness via video conferencing facilities, because obviously we had this idea of social distancing and bubbles and not being around people. That has now lapsed. That lapsed in January this year. So we are now back to a system. Countries like Australia, for example, I think even India, are looking at bringing in things like DocuSign and electronic signatures for wills. Under English law, we are still governed by an act that dates back to 1837. Yeah, we're still, almost 200 years behind. So under our laws, we still have to have a physical piece of paper for the will and physical wet signatures from the testator and from the witnesses. A couple of miscellaneous matters. I'll wrap up here because we're close to Salah time, and then we'll continue after Salah. We haven't even got to the complicated stuff yet, but are you all with me? Yep? Okay. Access to the original will on your death. The people that you appoint as executors must know where your original is kept. Now, Shaykh mentioned this hadith of keeping it under your will, and as he said, it's a metaphor. But your executors, the people that you have appointed, must know where the original will is, because if you die suddenly or unexpectedly, they need to know where that document is and how to access it. And most people that draw up their wills professionally with solicitors, with accountants, the solicitor or the accountant will hold it within their storage facilities, and they will provide the family with a copy, and you can circulate that copy to whoever you want. Most people just circulate it within the immediate family, but the original remains in a safe place with the professional who drafted it. So let your executors know that if so-and-so X firm has drafted your will, this is where they need to go. If you ever need to change your will, never ever alter it by making a mark on it, because that invalidates the will. You need to seek professional advice on what you can do to amend your will properly. Because if you just scratch things out, the court will look at that and say, somebody's tampered with it, with a legal document. And the court is very protective over people's wishes. They're very protective over wills. Because the way that they view it, they view it as something very sacred. This is your last words from the grave, right? So therefore, we want to make sure that whatever this person has said is observed as fully as possible. So never ever make an alteration to your will by writing on it or by marking it. It will need to be done in a separate document. Either you need to write the will again, or you need to do like an annex or an addendum, what we call a codicil to the will, if you want to make any changes. Never ever ever attach anything else to your will. Don't even bind your will with a staple or with a paper clip. Normally when we get them done professionally, we strip bind them or we ring bind them. Back in the day, we used to sew them, right? You see these old archaic documents with like the medallions, and that's how they used to be. The idea being is that the will can't be tampered with. It can't be taken apart. If there's even sometimes when you put a paper clip on a bundle of documents, it leaves a bit of a mark, right? If a court sees a will that has the outline of that mark, they'll say that this will has been tampered with. We're not going to accept it. That's how extreme they are, right?
So if your will is like 2 pages long and it's stapled,
yeah, it can cause problems. It can cause problems. So normally what you would do is you would put page 1 of 2 or page 2 of 2 at the bottom, and sometimes what people will do, they'll sign each page.
not stapled.
Well, no, in that case, if you're doing it like a homemade, we'll staple it, but then do like page 1 of 2 or 2 of 2 at the bottom. So it's clear that no pages have been added or taken out, right? That's key. But stapled wills have caused problems in the past, right? When should you review your will? I'll end with this slide because we're coming up to Salah time. When should you review your will? Whenever you have any major life event. So when you get married, if you get separated, if you get divorced, God forbid. Separation is one that people always forget. Often the divorce process can take a long time to happen, a couple of years whilst assets are being sorted out, arrangements for the children are being made. Divorce can take a long time to sort out. If one of you passes away in that interim period, you don't necessarily want your spouse inheriting the bulk of your estate, which is probably what you put in your will when you got married. Right? So separation is the key time to review the will, to make sure that if I die in that interim process before we're formally divorced, then the proper arrangements are in place to make sure my assets go down to the kids or to the parents or whoever else I want to benefit. If you have a birth or a death in the family, you've got a new child and the current will doesn't make provision for the child. Often happens. I have so many, I have clients that will say, they've got 3 children, and I'll say to them, I won't name your children in the will, I'll just put children. I give my estate to all of my children. And they say, no, name the children, because we're not going to have any more children, we're done. A year later, I got a call saying, actually, just had baby number 4, right? So the will need to be updated for that. If you have a change in your financial circumstances, so if you, for example, inshallah, your business takes off, your salary increases significantly, you inherit from somebody, and your wealth and your financial situation changes, that will inevitably have an impact upon how you want your estate to be distributed and how your estate will be taxed. So that is a key time to review. If there is a change in taxation, we've just had a huge budget, which I'll talk about briefly, but when there are major political changes like that, that's when the will needs to be amended. As a rule of thumb, I would say to all of my clients, generally every 5 years. Every 5 years. Take it out, sit down with it, make sure you understand it, make sure you're still happy with what it does, talk to your solicitor or the person that helped you draft it, explain any major changes that may have happened in that 5 years, and it may be that in that 5-year period, nothing has happened and you can put it back under your pillow and forget about it. But most people, something will have happened in 5 years that will come back to necessitate, even if it's something like, this child is more well settled and I now want to give more to this child because they're in difficulty, whatever it might be. Situations change, right? So every 5 years as a rule of thumb. I think we'll leave it there because we're coming up to Salah time, and we'll carry on from challenges to wills when, before we sort of stop, is everybody kind of with me so far? Yeah? Everybody with me? Good, okay.